Hello friends, we are starting with the lecture number 6 for the Indian Polity Conceptual lecture series, and in the last class we have finished till the fundamental duties. Also we saw certain articles which were related with the election of the president, the manner and the procedure of the president, and which is an important part to understand. Now in this lecture we are going to start with a fresh part of Indian Constitution, that is a part 5, which deals with the union government. And the chapter number 1 of part 5, it deals with the executives of the union. So we are already aware of the terms like the executives, the legislatives, and the judiciary. So chapter number 1, part 5, it deals with the executives of the union government. So let's start with the first article of this chapter number 1, which is article number 52, and it tells us the President of India, which gives us information that there shall be a President of India. So in the very first article under the executives of the Union, it tells us there has to be a President of India. Coming to the article number 53, which talks about the executive power of the Union. First part, it says the executive power of the union is vested in the president. So executive power of the union is vested in the president, and the president will exercise these executive powers either directly or through the officers subordinate to him in accordance with the constitution. So these officers, the subordinate officers, are normally the ministers. The second part, it gives us a very important information, and it tells us that the supreme commander of the defense forces of the union, okay, it is the president. So article number 53 part 2, it tells us the supreme commander of the defense forces. So supreme commander of defense forces is the president. Part 3 of the article number 53, it gives us the information that the Parliament has this power to confer additional functions on the President, or either it can take certain functions from the President and it can ask some other authority to perform those functions. So this is the article number 53 of the part 5, chapter number 1. Now article number 54 and 55, we have already dealt, those are related with the election of the president in the last class. Now coming to the article number 56, and which gives us information about the terms of office of president. First part, article number 56, it says the president shall hold office for a term of 5 years. So the term of office of president is 5 years from the date on which he enters upon his office, provided that A, the president may by writing under his hand address to the vice president resign his office. So from here, actually these little facts are very important, and they are asked very frequently in all the examination, that president gives his resignation to whom. So president gives his resignation to the vice president of India. Subpart B, now it says the president may, for the violation of the constitution, be removed from office by impeachment in the manner provided in article number 61. So it says that the president can also be removed from his position by parliament through the procedure known as the impeachment of president, which is there in the article number 61, and which we are going to discuss in some time from now, that what is the procedure of impeachment of president. President shall, notwithstanding the expiration of his term, continue to hold his office until his successor enters upon his office. Now what it means to say is, suppose the old president has already completed his term of 5 years, but due to some reason the election for the new president cannot take place. So this article says that till the time the new president comes in, the old president remains in his position. Okay. Now part 2 of article number 56 says any resignation addressed to the vice president. So if president gives his resignation to the vice president, now it is the duty of vice president to communicate the same thing to the speaker of Lok Sabha. Okay. So these are the terms of office of president. Coming to the next article, article number 57, it tells about the eligibility for re-election. So let's read that. A person who holds or has held office as president So the person who is a president now or who was a president before shall, subject to the other provisions of this constitution, be eligible for the re-election to that office. Now this is an interesting thing to understand. Now there is no limitation on the times of re-election for the same person on the post of president in Indian constitution. Whereas similarly, if we see in the US, a person cannot be elected for the post of president for more than 2 terms. Okay, but here there is no limitation. He can be re-elected to that position n number of times. So this article gives us this information, eligibility for re-election. Now coming to the article number 58, and it tells us about the qualifications which a person should has for the contesting the election of president. So first thing it says, he should be a citizen of India, has completed the age of 35 years. So these little informations you keep jotting down. The age limit is 35 years, minimum 35 years for the person to be a president of India. He should be qualified for election as a member of House of the People. So Lok Sabha, he should be qualified to be eligible for the member of Lok Sabha, to be a member of the Lok Sabha. Now part 2, it says that person shall not be eligible for election as president if he holds any office of profit. So this is an important statement. If he holds any office of profit under the government of India or the government of state. Now this article also gives the explanation for this particular term, that a person shall not be deemed to hold any office of profit by reason only that he is a president or vice president, or he is a minister of the union, or he is a governor of the state, or he is a minister in the state. So just for this reason, he does not deem to hold any office of profit. Now coming to the article number 59, which is the conditions of president's office. The president shall not be a member of either house of parliament, that is the Lok Sabha and Rajya Sabha, or of house of legislature of any state, and if a member of either house of the parliament, that is Lok Sabha and Rajya Sabha, or the house of legislature of any state, if that person is elected as the president, he shall be deemed to have vacated his seat in that house. Okay, so if a person who is a minister, suppose in a state legislature, and he became the president of India now, then he is deemed to have vacated that position of minister in the state legislature. The second part, it says the president shall not hold any other office of profit during his tenure. Third, the president shall be entitled without the payment of rent to the use of his official residence, that is the Rashtrapati Bhavan, we all know, and also entitled for such emoluments, allowances and privileges as may be determined by parliament by law, and until the provision in that behalf so made, such emoluments, allowances are specified in the second schedule. So here comes the schedules, which we have already learned in the mnemonics part. The part 4 of article number 59, it says the emoluments and allowances of the president cannot be diminished during his term of office. Okay. Coming to the article number 60, and it tells about the oath of affirmation by the president. So president, who takes the oath from president? So it is the Chief Justice of India, or if Chief Justice of India is not there, the senior most judge of the Supreme Court available. So this is again an important fact which we have to remember, that who takes the oath, and president takes oath from whom. So it is the Chief Justice of India, or if Chief Justice of India is not there, then the senior most judge of the Supreme Court who is available. Now comes the article number 61, which we have already seen. It talked about the president can be removed from his position to the procedure of impeachment of president. Now let us see how this impeachment works. First thing what we have to remember in this is, this resolution for the impeachment of president, of course for the violation of Constitution of India, it can be initiated either in Lok Sabha or Rajya Sabha. So both houses, they are free to formulate these charges on the president. Now suppose Rajya Sabha is moving this resolution for the impeachment of president. The second thing what we have to remember is, at least 14 days notice should be given to the president before moving such resolution. And this resolution has to be signed by at least 1/4 of the total members present. Okay, so Rajya Sabha is framing this resolution. So 14 days notice has to be given to the president, and it has to be signed by the 1/4 of the total number of members of that house. Now, the third step will be this Rajya Sabha will pass this resolution by a majority of 2/3 of the total members of the house. So suppose now Rajya Sabha, this resolution is passed in Rajya Sabha by the members, by the majority of 2/3 of the total members of the house. Now it will go to the Lok Sabha. It will go to the Lok Sabha. Now Lok Sabha, what it will do is it will investigate these charges on the president, and president has the right to appear in all such investigations. So Lok Sabha will investigate the charges. And president has right to appear in such investigations. Now the fifth will be Lok Sabha also passes this resolution by a majority of 2/3. So once the Lok Sabha also passes this resolution for the impeachment of president stands removed from his position from the day this resolutions come into effect, or from the day this resolution is passed. Now let us read this article number 61. So first thing it says, the charges shall be preferred by either house of the parliament, which we have already seen. It can be initiated either by the Lok Sabha or by the Rajya Sabha. The second thing it says, at least 14 days notice should be given, and it should be signed by at least 1/4 of the total members of the house. Now such resolution will be passed by the 2/3 of the total membership of the house. In our case it was the Rajya Sabha who was initiating the resolution. Now when it comes to the other house will investigate the charges. Okay, and the president shall have the right to appear and to be represented at such investigations. Now, if as a result of the investigation, a resolution is again passed by the second house, but not less than 2/3 of the total membership of the house, the president stand removed from his position, and till date, no president has been impeached. This we all know. Now coming to the next article, which is the article number 62, and it tells us about the time of holding election to fill vacancy in the office of president and a term of office of person elected to fill the casual vacancy. Now there are two things in this. The first thing is the president has completed his normal tenure. He has already completed his normal tenure of 5 years. So the first thing it says that the election for the new president should be held before the expiry of the term of the old president. So it should be there within the 5 years, okay, before the completion of 5 years of the old president. But suppose now, due to some reason, that election cannot take place. Now what will happen is the old president will continue to hold the position unless and until the new president comes to take the post. Now second thing is, now he has not completed his normal tenure. This normal tenure he has not completed, and he has resigned or he has been removed from the office through the process of impeachment. So in this case what will happen is the vice president now will take the post of president. Okay, will take the post of president, and the constitution now here defines a very important time frame that in such cases a new election has to be taken place within 6 months period. So an election to fill a vacancy in the office of president occurring by reason of his death, resignation or removal shall be held as soon as possible after in no case later than 6 months from the date of occurrence of the vacancy. So this time period becomes very important for us, and in this case vice president acts as the president of India. And another important thing what this article says is the person now who will come for the president will hold the office for complete 5 years of terms, okay, from the date on which he enters into the office. Now this 6 months, actually this defining of 6 months, it is not there with the vice president. In case vice president post becomes vacant due to the death or the resignation or the removal of the vice president, this particular time period for the holding up of the fresh elections is not mentioned in case of vice president, but it is clearly mentioned in case of president that it has to be taken place within 6 months. So this is what this article tells us about. These were some of the facts which are very easy to understand and which we have to remember and which are asked very frequently. Now we comes to the different powers which are enjoyed by the president. Okay, so the first thing are the executive powers which are enjoyed by the president. The first thing we have already seen under Article number 53, that the executives of the executive actions or the executive powers of the government of India are taken in the president names, and what it means is all contracts, assurances of the properties are made by government of India, that is the union government, in president's name. All executive powers of the union are vested in him, and these powers are exercised by the president either directly or through subordinate officers. So this thing we have already seen under Article number 53, which talks about the executive powers of the president. Now, second thing which comes with the executive powers of the president are the powers of the president to appoint certain very important members of the executives of the union. Like first are the prime minister and other ministers. Now the thing to understand here is the appointment of prime minister and other ministers is not a discretionary power of the president. What it means is president has to go with the party who has got the majority of the seats in Lok Sabha. So it is not a discretionary power of the president. He has to invite the party who has got the maximum seats in Lok Sabha. And for the other ministers also, the appointment of other ministers has to be done on the advice of prime minister, attorney general, and his remuneration are decided by the president, and he stays during his pleasure. Comptroller and auditor general, chief election commissioners and other election commissioners, chairman and other members of UPSC, the governors of the state, and in this again advice of chief minister are not sought for the appointment of governors for that particular state. Third point is the appointment of different commissions and councils, which is also the executive power of the president. The different commissions which president formally to look into the conditions of scheduled castes, scheduled tribes and other backward classes. The councils, the different councils which are framed by the president to promote the cooperation between the central government and the state governments and between different states. Fourth point is the administration of union territories through administrators. Now we know we have 7 union territories. So presently, if we see the union territory of Andaman Nicobar, the union territory of Delhi and Pondicherry, the administrators of these three union territories, they are being designated as the lieutenant governors. Okay, while for the Chandigarh, the governor of Punjab is looking as the administrator for the Chandigarh. The administrator of Dadar and Nagar Haveli is looking after the administrator job of Daman and Diu, while Lakshadweep has a separate administrator. So this is how the president rules these union territories to the administrators. Fifth one is declaration of schedules and tribal areas in a state, and the president has the power to administer these scheduled and tribal areas directly. Now comes the sixth point, which is a very important power, that is the pardoning power of the president. And please remember here is this pardoning power is the executive power of the president, executive power, and not judicial power. So this is a major confusion actually which students have, that pardoning power is the judicial power of the president, but it is not true. And in case in exam, if you will get the question that pardoning power of president is a judicial power, executive power, legislative power, please remember these are the executive power independent of the judiciary. So not judicial power, these are the executive power. Please note these things down. Article number 72, power of, so article number 72, it tells us about the pardoning power of president. Power of president to grant pardons, etc., and to suspend, remit, or commute sentences in certain cases. President shall have the power to grant pardons, reprieves, respites, remissions of punishment, or to suspend, remit, or commute the sentences by any person convicted of any offence in case when the sentence is by the court martial in all cases where the punishment or sentence is for an offence against any law related to a matter into which executive power of the union is sent, or in all cases where the sentences is a death sentence. Now it gives explanation also. Nothing in clause A of clause 1, subclause A of clause 1, shall affect the power to suspend, remit, or commute a sentence of death exercisable by the governor of a state. So governor of a state also have these powers, okay, except the pardon power of death sentence that we will see. Governor of state under any law for being for any law which is in force that time. Now, the Constitution of India, it vests sovereign powers in President and governors. The governance in the central and state are carried out in the name of President and the governors respectively. We know that. The President is empowered with the power to pardon. Okay, power to pardon sentences confirmed by the court or the martial court under Article 72 of the Indian Constitution. Okay, and these four terms which we have to understand to grant pardons, reprieves, respites, and remissions and commutation. So first is the pardon. It means complete pardon. Complete pardon from all the sentences, from all the convictions of the convict. Second is the temporary suspension of sentence, reprieve. What it means is, suppose a person has got death sentence and he has to be hanged in this month. So there will be a temporary suspension of that particular order and he may be given 2 more months after that. Third is respite, which means awarding the less sentence. Fourth is remission, which is reducing the amount of sentence, and fifth one is commutation, which is changing one punishment to another, like the lesser sentence. What it means is, suppose if person has got the death sentence, so he can commute it to the life imprisonment in respect of offences done by the convict. Now, similar to the article number 72, we have article number 161 in which governor of a state has also been conferred these powers of pardon. Okay, so there are 2 major differences between the pardoning power of the president and the governor. The first is the governor does not have this power to grant pardons and these things against court martial. And second, governor also cannot pardon death sentences. So these 2 are the important differences between the pardoning power of the president and the pardoning power of the governor of a state. The question is that whether these power of granting pardon is absolute, or this power shall be exercised by the president on the advice of Council of Ministers. So the answer is the pardoning power of the president is not absolute and it is governed by the advice of the Council of Ministers, though these things are not discussed or explicitly mentioned in the Constitution, but this is a practical truth. Further, the Constitution does not provide for any mechanism to question the legality of these decisions of the president for the granting of pardon, but in Supreme Court, in a very important case, Ipuru and Sudhakar case has given a small window for judicial review of the pardon powers of the president and governor for the purpose of ruling out any arbitrariness. So this is about the pardoning power of the president. Important point to understand. Many times these are being asked in the subjective as subjective questions also in the mains examinations of various competitive examinations like state services and UPSC also. Now coming to the 7th point of the executive powers of the President, Article 78 provides that it shall be the duty of the Prime Minister to communicate to the President all decisions of the Council of Ministers related to the administration of affairs of the Union and proposals for legislature. To furnish such informations related to administration as President may call for, and if the President so requires, to submit for the consideration of Council of Ministers any matters on which the decision has been taken by a minister but which has not been considered by the Cabinet. So this is again we will see when we'll see the Council of Ministers also, the relation between the Council of Ministers and the President. Point 8, the President has the right to know what this government is doing or proposes to do. But the question how much information is to be furnished by the Prime Minister to the President is the prerogative of the Prime Minister. And this should be the matter to be resolved by mutual confidence and cooperation between the two, that is the President and the Prime Minister. Now, completing the executive power of the President, we come to the legislative powers of the President. Legislative, we know, the lawmaking process. So the first thing which we have to learn is the powers related with the Parliament, and why it is considered as the legislative power of the President, because it is the lawmaking institute. So these powers of the President in relation with the lawmaking institute of the Union, which is the Parliament. Parliament is composed of President, Lok Sabha and Rajya Sabha. So this thing, it's given in the Constitution, what we will also study once we will go to the Parliament section. So Parliament is composed of the President, the Lok Sabha and the Rajya Sabha. So President of India is an inseparable part of the Indian Parliament. The President has the power to summon or prorogue the two houses of the Parliament. After the prorogation, House must be summoned within 6 months. So these are the important facts which we'll study in the Parliament part also. So President has the power to start or to end the session of the Parliament, and after one session, the second session should not be paused for more than 6 months. So it is given in the Constitution. The President may dissolve Lok Sabha only when the government gets no confidence motion or the no confidence motion is passed, and we know Rajya Sabha is never dissolved. After general elections, President addresses both the houses of the Parliament, and he may address either house or even a joint sitting. We will see what is the meaning of joint sittings of Parliament and for what purposes these joint sittings are called. So President can call for a joint sitting of the Parliaments. President may nominate 2 members of Anglo-Indian community in the Lok Sabha if he feels that the community is not represented adequately, which is given in Article number 331. President has power to nominate 12 members of Rajya Sabha if they excel in art, literature, science, social science, culture, etc., which is given in Article number 80. So these are some of the important articles which we can mug up also, which helps us in prelims and also in mains while writing examinations. A bill passed by the Parliament becomes an act only once the President has given an assent to it. So that is how President becomes an inseparable part of the Parliament or the legislative procedure of the Parliament. So a bill which is passed by both the houses cannot become act if President doesn't give his assent. So there are some bills which require prior recommendations of the President, and this means that the bills needs to be introduced in Parliament only on the recommendation of the President. This thing we have already seen. Certain bills which can be introduced in the Parliament only after the recommendation of the President. The first one of such is the bill that seek to alter boundaries of the state and name of the state, that Article number 3, which we have seen in the first class itself. The money bill as per Article number 1110 and the financial bills can be introduced only after the recommendation of the President. Any bill which affects a taxation in which states are interested, Article number 274. State bills which impose restrictions upon the freedom of trade, Article number 304. So in this we see mostly the things which are affecting the jurisdiction of the states. The recommendation of presidents becomes important for those bills before the introduction into the Parliament. Now, second thing which we have to understand are the veto powers which President has related to bills. And this thing we will study in 2 parts. The first part is the bills of central legislation and second part will be the bills of the state. So when a bill of the central legislature it is presented to the President has 3 alternatives, and this is given in Article 115. The first option which President has is he may give assent to the bill. So once he gives the assent to the bill, it becomes an act. So this is the easiest option for the President to give the assent to the bill. Now second is he can withhold his assent. He doesn't give his assent. The third is he may return the bill for the reconsideration, and this can be done only if it is not a money bill. These concept of money bill and financial bill we'll study in next lecture when we'll talk about the parliament. So he may return the bill, but only in case if it is not a money bill. Money bill cannot be returned by the president again for the reconsideration of the parliament. And if bill is again passed by the parliament, okay, then president has to give his assent. He doesn't have any choice. So this is also known as the suspensive veto. Suspensive veto of the president. So this is very simple. Bill goes to president. So first thing what he can do is give his assent to the bill. Okay, this bill is okay. It becomes an act. Second is he can withhold his assent. He will not return the bill to the parliament for the reconsideration. So this is how bill can now never become an act. Now the third thing is he can return the bill. He is returning the bill to the parliament. He is asking you reconsider these points. I think these are not right. And this can only be done in case of money bill. Money bill cannot be returned back to the parliament. So money bill, a president will have two obvious choices now. He can give his assent, and second is he can withhold his assent. But normally he cannot or he don't withhold his assent because these money bills we have seen can be introduced in the parliament only on the recommendation of the president. So there is no question for the president now to withhold his assent. Now there are different types of bills. The first are the ordinary bills. In case of ordinary bills, which means actually ordinary bills are the bills which are introduced by the private member of the parliament or the members which are not the ministers. So president can just keep the bill in his pocket and forget it, like what we have seen, withhold his assent. So when president neither gives his assent or not returns the bill, it is also known as the pocket veto. So pocket veto is applicable only to the ordinary bills, and this is known as the absolute veto. Absolute veto because now president is having absolute power. He will have the power to see that this bill doesn't become an act. So in ordinary bill, he has this absolute veto. Now second cases are the constitutional amendment bills. The President of India, it enjoys absolute veto on constitutional amendment bill till 1971 only. The article number 368(2) before 1971 stated that it shall be presented to the President for his assent, and upon such assent being given to the bill, the Constitution shall stand amended. So in this case, the assent of president is becoming very important. But now the situation changed in 1971, and by 24th Constitution Amendment Act 1971, it was changed to it shall be presented to the president who shall give his assent to the bill and thereupon. Now here it becomes mandatory for the president to give his assent to the bill. Okay, so now he doesn't have absolute veto. He cannot he cannot withhold his assent to the bill. So this means that now for the constitutional amendments, these cannot be questioned by the president or any court of law. But we have seen the basic structure of constitution. It still remains under judicial review. Now third type of bills are the money bills. So in case of money bills, we have already seen it has to be introduced into the parliament after the recommendation of the president, and president cannot return these bills to the parliament for the reconsideration. So president may either give or withhold his assent to the money bill. He doesn't have the third choice of giving it back to the parliament. And under the constitution, a money bill cannot be returned to the house by the president for the reconsideration. Now this was about the central legislature, bills from the central legislature. The second part is the bills of the state legislature. Now state legislature, when it passes a bill, it will become an act only when governor gives his assent. Same as in case of central, we have in state the governors. So now when a bill is presented by the state legislature and by the state legislature to the governors. Now he has four alternatives. One more alternative than president. He may give his assent to the bill. The simplest option, the bill will become an act. May withhold his assent. So bill cannot become an act now. He may return the bill if it is not a money bill for reconsideration. So same thing comes here also. President also cannot return the money bill to the parliament. Okay. Same thing is with the governor. Governor cannot return the money bill of state legislature back. So he doesn't have this option. Same as with president. Our third option, the additional option here with available with the governor, may reserve the bill for the president assent. So here the role of president comes. Now suppose the governor reserved the bill for the president assent and he presented the bill now to the president. Now again here president have three options. Okay, first thing is he may give his assent. Simplest option. He may withhold his assent again. So bill cannot become an act. Now third is he may return for reconsideration. And if state legislature again pass the bill and governor present the bill before president, president is not bound to give assent. This is in contrary what is happening with the central legislation. Now central legislation we saw. Now president is returning back a bill to the legislature to reconsider it. But now if central legislature again passes that bill with or maybe without amendment, president doesn't have any choice and he has to give his assent to that particular bill. But in case of state legislature, now what is happening is if he is returning back for the reconsideration, president to the state legislature, and if state legislature passes that bill with or without amendment, now president is not bound to give his assent. He may again give it for reconsideration or he may again withhold his assent. I think it is very clear, it is very simple to understand also, and we will also again revise these things at the end of the lecture. Now these were the powers of the president related with the legislatures, or which are the law-making body of the country, which are the that is why we are also calling it as the legislative powers of the president. Now comes the law-making powers of the president, the certain laws which president can make. So the very important question is the ordinance, promulgation of ordinance by the president. So what is the ordinance? Under the constitution, the power to make laws rests with the legislature. Rests with the legislature. Very obvious. Legislature only make laws. But however, in cases when parliament is not in session and immediate action is needed, the president can issue an ordinance, and ordinance is a law and could introduce legislative changes. So it gives us information that president has the power to make certain laws and promulgate them, which we call as ordinances, but only when the parliament is not in session. And it may happen then what parliament is in session and other parliament is not in session. So in this case also president can promulgate an ordinance. So the most important power of president is perhaps to promulgate ordinances under article number 1, 2, 3. You have to remember these articles. Article number 72, the powers of pardon. Article number 123, which says the power to promulgate ordinances. And this is a very hot topic now these days. Ordinances which have been issued by the central government. So it becomes a very important question this year. The promulgation of an ordinance is not necessarily connected with an emergency, but issued by the president in case if he is convinced that it is not possible to have parliament enact a law on some subject immediately and the circumstances render it necessary for him to take immediate action, which is given in article number 1, 2, 3, part 1. However, such an ordinance must receive parliamentary approval within 6 months of the next session of the parliament. So now president passes a ordinance. Now when the parliament again comes in session, this ordinance has to be made or it has to be passed by the parliament within 6 weeks of its reassembly. Okay, or otherwise it shall become valid. Now what is happening with the land bill? Okay, since the ordinance making power is to be exercised by the president on the aid and advice of the council of ministers, which is there in article number 74, the power is often misused. Now another thing to understand here is these ordinance making power of the president will have the same limitation as with the central laws. For example, it cannot abridge a fundamental right, it cannot violate the basic structure of the constitution. And also, one important thing is these ordinances cannot be passed to amend the constitution. So, important point to understand is cannot be issued to amend the constitution. To amend the constitution. A very important point to remember, cannot be issued to amend the constitution. Now if we see now, we have seen that it has to be passed by the parliament once it reassembles within 6 weeks. So maximum duration of the ordinance can be 6 months plus 6 weeks, isn't it? Because 6 months is the maximum duration for the recess of the parliament, and 6 weeks it has to be passed. Another thing is these ordinances can be re-promulgated. Okay, there is no as such restrictions, but there has been certain court rulings that the re-promulgation should not take place because the fundamental the process for the lawmaking lies with the legislature and not through the process of ordinances. Now coming to the emergency powers of the president, we have done with the executive power of the president, the legislative power of the president. In legislative powers of president, we saw the powers related with the legislative body of the country, that is parliament and the state legislature. Then the lawmaking power of the president itself, that is the ordinance, article number 123, very important. Now we come to the emergency powers of the president. The president may proclaim a state of emergency in the whole or in certain specific part of the country if he realizes or feels that a grave situation has arises in which the security of India on part of its territory might get threatened by war or external aggression or rebellion. Article number 352. Now, President can declare 3 types of emergencies. We have 3 types of emergencies. These things we will again discuss when we discuss the emergency provisions which are there in the Constitution. Now, just for the sake of the President power, let us discuss them. The first one is a national emergency. National emergency is caused by war, external aggression or armed rebellion in the whole of the country or in a specific part of the territory. The the President can declare the national emergency only on written request by the cabinet ministers headed by prime ministers, and the proclamation of this particular national emergency, it has to be approved by the parliament within 1 month. National emergency can be imposed for 6 months, and it can also be extended by 6 months by repeated parliamentary approval up to the maximum of 3 years. And we have seen when we were studying the fundamental rights, under national emergency, the 6 freedom under the right to freedom are automatically suspended, but the right to life and personal liberty cannot be suspended. We have 3 times these national emergencies which were declared. First was the 1962 Chinese War, 1971 Pakistan War, and 1975 to 1971, which was declared by the Indira Gandhi on account of internal disturbance, which was also a very controversial step till now. The second type of emergency are the state emergency or the president rule in a state. A state emergency can be imposed by the following. The first one is if that the state failed to run constitutionally or the constitutional machinery of that state failed, which is there in the article number 356, and if that state is not working according to the given directions of the union government, article number 365. Such an emergency must be approved by the parliament within a period of 2 months. Please remember the durations here, it is 2 months, and for the national emergency it was the 1 month approval was required. And it can be imposed from 6 months to a maximum period of 3 years with repeated parliamentary approval every 6 months. If needed, the emergency can be extended for more than 3 months by a constitutional amendment. For example, what happened in case of Punjab and Jammu and Kashmir, we already know. During such emergency, the governor of that particular state administers the state in the name of the president, and the legislative assembly, it can be dissolved or it may remain in suspended animation. Parliament now will have the power on all the state subjects to make laws on those state subjects which are there in the state list. Now, if I ask you if you have completed the mnemonics part, which schedule has this central list, the state lists, and the concurrent list? If you have completed the mnemonics, it should immediately come to you the seventh schedule, the seventh, that is heaven. Okay, so that is how mnemonics plays a very important role, and these questions are asked every year about the schedules and other important articles with their numbers. And the third type of emergency, we are discussing the emergency, is financial emergency, which is there in article number 360. The president can proclaim a financial emergency if financial stability or credit of India or any part thereof is threatened. And this proclamation must be approved by the parliament within 2 months. And this type of emergency has not been declared so far, we know that. So here also it has to be approved by 2 months. So these are the important factual information, you just note it down. Okay, for the national emergency, 1 month, within 1 month approval is required. For the other two emergencies, it is 2 months approval which is required. Coming to the financial powers, a money bill can be introduced in the parliament only with the president recommendation. We have already seen that. The president lays the annual financial statement, that is the union budget, we will see in the next lecture, before the parliament. The president can make advances of the contingency fund of India to meet the unforeseen expenses. This also will see the different types of funds which are available with the union government. The president constitutes a finance commission after every 5 years to recommend the distribution of taxes between the central and the states. So these are termed as the financial powers of the president. Certain diplomatic powers, the international treaties and agreements are signed on behalf of the president. However, they are subject to the approval of the parliament and mostly the cabinet ministers. The president represents India in international forums and affairs and may send and receive diplomats like ambassadors, high commissioners. So these are terms that are diplomatic powers of the president. The military powers, the president is the supreme commander of the defense forces of India, article number 53B. Okay. President can declare war and conclude peace, subject again to the parliamentary approval. These are not the discretionary power of the president. The president appoints the chief of army, navy and air force. So these are considered as the military powers of the president. Judiciary power, the president appoints the chief justice of the union judiciary and other judges on advice of chief justice. These things we will discuss in more detail now because it's a hot topic these days for the appointment of judges. President dismisses the judges if and only if two houses of the parliament pass resolution to that effect by 2/3 majority of the members present. These things we'll discuss when we'll go to the judiciary part, the union and the state judiciary. The president enjoys certain judicial immunities. No criminal proceedings can be initiated against the president during the term in office. So no criminal proceedings can be initiated against president when he is a president. Okay, president is not answerable for the exercise of his duties. This was all about the president. Now we come to the second part of the union executives. The first was the president. Second is the vice president. So first thing is who can be the Vice President of India. So the eligibility criteria to become a Vice President are laid down under Article number 63, which tells about the election of the President. And article says that a candidate to become Vice President of India should be a citizen of India, the first condition. The second condition, completed the age of 35 years, same as the President. For president also eligibility was 35 years. Should be qualified for election as a council of state. Important point to remember. Here is the first difference between president and vice president. The president election must be qualified for the election as a member of house, that is Lok Sabha, while for the vice president he should be qualified for election as a member of council of states. And these things we will discuss in this class when we will go about when we'll study the parliament, both the Lok Sabha and Rajya Sabha. And he cannot hold an office of profit. Same holds true for the president as well. So what are the functions of vice president? Vice president is the executive chairman of the Rajya Sabha. and cannot hold any other office of profit however, during the period when he or she acts as an officiating president of India. Okay, that we have seen when president dies or president is removed to the process of impeachment or president resigns, he shall not, and vice president becomes a president now. The vice president shall not act as the chairman of the Rajya Sabha during that time and shall not be entitled to the salary or allowances payable to the chairman of the Rajya Sabha. Article number 65, it says that in case the president is unable to discharge his or her duties for reasons such as illness, resignation, removal by impeachment, death or otherwise, the vice president will carry out the functions of the president, and in these circumstances he or she shall be entitled for the salary and allowances and all privileges which are extended to the president. Election, term of office, removal and oath. The Vice President of India is elected by both houses of parliament, that is Lok Sabha and Rajya Sabha, including nominated members. Okay, which was not the case with the president. Nominated members didn't used to take part in the election of the president. And if you have noticed, when we discussed the process of impeachment, that time the voting or the houses which passes the resolution or the second house, nominated members also took part in that election, okay, or that process of impeachment. But in case of election, nominated members didn't take part. So this is also one factual information which you should remember. For the election of the president, nominated members doesn't take part, okay, either for the union legislature or for the state legislature or for also the union territories of Delhi and Pondicherry which participate in the process of election of president. But in case of impeachment, which is done by only the central legislature, the nominated members also take part. Okay, please note down these things. But here vice president is elected by both houses of parliament, that is Lok Sabha and Rajya Sabha. The MLAs have no role to play in election of vice president, that is the state legislature doesn't take part in the election of vice president. The vice president functions as president of the whole country when president is not there, but the state electors have no role to play in this. Okay, so this is obvious and understood. The original constitution laid down the method of election of vice president of India by members of both houses of parliament assembled at joint sittings. So this was the original test of the constitution, that the election of vice president will take place in a joint sittings of both the houses. But later this was removed, and now we don't have joint sittings for both the houses for the president, for the election of vice president. And election of vice president now takes place of a electoral college consisting of members of both the houses in accordance with the system of proportional representation and by means of single transferable vote. These two terms are very conceptual and we have understood its meaning when we were studying the election of president in the previous class. The doubt and disputes which are arising out of election of president or vice president can be challenged in Supreme Court. So, election for the president and vice president can be held void by the Supreme Court. The term of office of vice president is 5 years, and the term may terminate earlier by resignation, which should be addressed to the president, and the term may also terminate either by the removal. A president can be removed by a resolution by the members of Rajya Sabha. So again, a big difference between the president and the vice president. Here the vice president can be removed by a resolution only initiated by the Rajya Sabha, while in case of president, the resolution can be initiated either by the Lok Sabha or Rajya Sabha, and to move such resolution of 14 days notice has to be given, same as the president, and such a resolution though passed by the Rajya Sabha, it must also be agreeable to the Lok Sabha. Okay, so there is no impeachment process as such for the vice president. Resolution is moved by the Rajya Sabha and it has to be agreed by the Lok Sabha as well. While the president takes oath of office to preserve, protect and defend the constitution. and the law. The Vice President takes oath of true faith and allegiance to the Constitution of India as by law established. So these are the differences between the oath for the office of President and the Vice President. Now we come to the third part of the Executives of the Union, and which is the Council of Ministers. And Article number 74 and 75 of the Constitution of India deal with the Council of Ministers and the Prime Minister. Article number 74(1). There shall be a council of ministers with Prime Minister at the head to aid and advise President, who shall, in the exercise of his function, act in accordance with such advice. So, President has to act on the advice of the Prime Ministers, and Prime Ministers is the head of the Council of Ministers. The President may require the Council of Ministers to reconsider such advice, and President shall act in accordance with such advice reconsidered. This we have already seen. Okay, so he has to act, or the advice of the Council of Ministers and the Prime Minister on President, it is binding on President. So Council of Ministers here becomes the real executives. Article number 74(1), it makes the Council of Ministers the real executives in our country, and this article mentions that the President shall act in accordance with the advice tendered by the Council of Ministers. The President may ask the Council of Ministers to reconsider the advice, but if the Council of Ministers decides to stick to the previous advice, President have no choice, and he has to act as per the reconsidered advice. Article number 74(2), it tells us that what advice this now Council of Ministers and Prime Minister is giving to the President, it cannot be inquired into any court. So indirectly it is giving the relation of Council of Ministers and President is a confidential one. An advice tendered to the President by Council of Ministers cannot be inquired by anybody, and this has been made clear by Article number 74(2) of the Constitution. Coming to the next article, which is Article number 75(1), the Prime Minister shall be appointed by the President, and other ministers shall be appointed by the President on the advice of the Prime Minister. So not a discretionary power of the President to appoint Prime Minister. Okay, he has to go with the majority party of the Lok Sabha. The minister shall hold office during the pleasure of the President. So it doesn't mean that President, whenever he wants, he can remove a minister. It is only the Prime Minister who can give an advice to remove a minister. The Council of Ministers shall be collectively responsible to the House of People. This collective responsibility we have seen once we were studying the concepts of the polity, the collective responsibility and the individual responsibility. Article number 75(4), before a minister enters upon his office, the President shall administer to him the oath of the office and of secrecy according to the form set out for this purpose in third schedule. Third schedule we have already seen, it contains oaths. Article number 75(5), a minister must be a member of any house within 6 months. So a person who is not the member of any of the houses can also become a minister, but within 6 months of time he has to get a membership of any of the houses. This thing also I think we have discussed, and it's an important fact to remember. The Parliament will decide the salary and allowances of the ministers, and until Parliament decides, shall be specified in the second schedule. We have already seen second schedule what it contains. The minister shall hold office during the pleasure of the President. Okay, this thing we have seen. Now, all ministers are appointed by the President on the advice of the Prime Minister, and it is the Prime Minister who actually allocates different portfolios to different ministers. So, Prime Minister may call for resignation of any minister at any time, and in case the minister refuses to give the resignation to the Prime Minister now may advise the President to dismiss the minister. So, it is not President who can directly dismiss a minister, it is always on the advice of the Prime Minister. So this is also known as the rule of individual responsibilities. Ministers are from both Lok Sabha and Rajya Sabha. This thing also we have seen. Moreover, we'll see in Parliament lecture also. A minister must be a member of any of the houses within 6 months. This means that the Prime Minister may choose ministers from Lok Sabha or Rajya Sabha. or a person who is not the member of either houses of the parliament may also be appointed as a minister, but the maximum duration a person can remain as a minister without being a member of either of the house is 6 months only. So he or she must be able to secure the seat in either of the house within this time period. Article number 75(5). Now, Council of Ministers will be collectively responsible to the House of People. We have seen Article number 75(3) of our Constitution incorporates the principle of collective responsibility. And this article says that the Council of Ministers shall be collectively responsible to the Lok Sabha. So, if the government loses the confidence, all of these ministers has to go away. This means that the ministry loses the confidence of the Lok Sabha. All ministers, including those who are from Rajya Sabha, have to go. So the entire ministry is obliged to resign in case the government loses confidence in Lok Sabha, and this means that ministers fall and stand together, and this is known as the rule of collective responsibility, which we have seen. Now, talking about the Council of Ministers. Council of Ministers is a big team, okay, maybe around 60 to 70 ministers. Now these council of ministers, they are of three different categories. The highest one are the cabinet ministers, which are mostly 10 to 15 who hold the important portfolios in the government, like the finance ministry, the defense ministry, the home ministry. And the second category now comes with the minister of states. They actually can hold the individual portfolios also, or they can be attached with the cabinet ministers. So they are second in rank, and then comes the third in rank, the deputy ministers, who are attached with the different ministers to help them in discharge of their functions. So please remember the differences between the Council of Ministers and the Cabinet Ministers. So Cabinet Ministers actually are the part of Council of Ministers, but they are the highest ranked ministers, and they take part in the cabinet meetings and take the bigger decisions. Now there are two types of cabinet committees. We know that, and we will also discuss in future the standing committees and the ad hoc committees. Standing committees are the permanent committees, and ad hoc committees are the committees which are made to serve some specific purpose, and then they are dissolved after that. So here we finished this particular part of the executives of the union. This was an easy part to understand, and you start making your own short notes of this chapter, and you will see once we will discuss the last year question papers, you will see most of the questions actually fall from these short notes only. So polity, Indian polity is comparatively an easy subject to understand, because most of the things we see actually daily in the newspapers and the TVs, we have to learn them in the book, and some important informations and facts, some tricky questions will be there. So these all things we'll see once we'll go through the last 20-year question papers of the Indian polity. So here we finish this part, and next class we are going to start with Indian Parliament. So keep revising things and keep going to the newspapers daily, and start now linking whatever you are reading from the textbook to the practicals, whatever is happening around us. So thanks for tuning in.